recluse of sorts. Anyway, so about two-thirds have been called to jury duty, and 1/4 have actually served. Juries have been criticized because of the excessive awards that they give to in civil courts, in civil cases. Juries also have their defenders. Verdicts reached by representative juries can and often do increase the legitimacy of the process in the eyes of the public, particularly in controversial trials. Of course, we all know of controversial trials. There's the lady that theoretically murdered her child down in Florida. She was acquitted. O.J. Simpson was acquitted. So it's really kind of interesting to look at whether juries are doing the right thing or doing the wrong thing. Some people think that they're uneducated individuals. Why do they have the right to make these decisions? But of course, that's the way the legal system works. That's the way it's put together. Psychologists have examined factors that affect the accuracy of jury verdicts. We have learned that evidentiary strength is probably the most important determinant of juries' verdicts in both civil and criminal cases. And in other words, how strong is the evidence going in one direction or the other? And usually they will accept that. Most people take their jury duty very seriously, so they're not just trying to make things up. But of course, we have seen juries that acquitted individuals that theoretically were guilty. We saw this in the South, where all the juries were white, and the defendants were black, and the black defendants were always convicted. Really a serious situation. They had the individuals that blew up the little girls in Birmingham. The 5 little girls, killed the 5 little girls. 5 little black girls in a black church. They blew up the church, and the 5 girls were killed. They were acquitted. And it took them 25 years to bring them into justice. There were 3 men, and one of them, it took 25 years to get him in prison for blowing up the church. Initially, of course, with the first trial, they were all acquitted by an all-white jury, of course. Effects of extra-legal information. Juries' decisions can be influenced by extra-legal information. In other words, irrelevant information in the defendant's background, appearance, and their race. All of these things will be noted by the jurors. If there is information, and of course, if you've ever watched these trials on television, they used to actually televise this stuff. Not so much anymore. If you've ever watched a television show about trials, a lot of times they're bringing up the character of the defendant. They're talking about the background of the defendant. Sometimes this is irrelevant information. Why in the world would you talk about the fact that he was molested as a child? Why in the world did you bring this up? Is this relevant to the case? The answer may be no, it's not really relevant to the case. But of course, the fact that this did happen to him, the jury will actually take this into account as to what's going on with the individual and as to whether he's guilty or not. Appearance is huge. And this is one of the things that lawyers will do. They will try to dress up their client, to make him look like a solid member of the society. If he's got piercings, he'll take the piercings out. If he has tattoos, he'll try to cover them up. He'll try to put a suit on him, on him, or if it's a young lady, of course, if she's got her head shaved, he'll cover it up with a hat to make them look like a solid member of society. So appearance is huge. Race is gigantic, and we talked about this in cultural psychology. We talked about the fact that there is a young man who is so god-awful gorgeous that he was released from prison early, and now he's a model. As horrible as that seems, the fact that he's tall and slender and very attractive. He's got tattoos. He's got prison tattoos up and down his neck. Despite that, because he has these gorgeous light blue eyes, he's an African-American gentleman. He's got these gorgeous light blue eyes. Women just went gaga over this guy. And they decided that he's too pretty to be a criminal. So they let him out of prison early because of the way he looks. Same thing happens with women. A pretty lady isn't convicted. It's just the way it works. African Americans are more likely to be convicted than anybody else. One of the things we're going to learn is that 1 out of every 3 African American males will be incarcerated sometime in their lives. 1 out of every 3. Is it because they're just naturally criminals? African Americans are just naturally criminals? 1 out of every 6 Hispanics will be incarcerated at some time during their lives. 1 out of every 17 white people will be incarcerated sometime in their lives. Is it because black people are so evil? Wait a minute. What do we know from religion? Religion teaches us, what's the mark of Cain? Could it be skin color? Some people actually believe that. Jeff's laughing. Sorry.
Sorry.
No, of course not. But race is huge. I mean, this is gigantic. Appearance is huge. Here's something else that you may not realize. Spike Lee realized it because that's usually what he talks about in his movies. The darker complexion an individual is, the more likely that they will be seen as evil, as negative. So if you are lighter complexioned, if you're an African American with a lighter complexion, you're less likely to get into trouble. The closer you are to passing, P-A-S-S-I-N-G, passing, it's what they refer to individuals who look almost white. If you are passing, then you are less likely to be convicted of anything. As confusing as that is. This is all extra legal information. So the darker complexioned you are, the more likely that you will be convicted. I don't know if you remember Barack Obama used to be president of the United States. Remember Barack Obama? His father was African. He was a black African. He was very dark. And for that reason, there were a lot of people in the United States that didn't like Barack Obama because they saw pictures of his father. As strange and horrible as that seems. So the darker complexioned you are, the more likely you are to be convicted. Is that true of natives? I don't know either. I'm not exactly sure. So the lighter complexioned you are, the more likely that you will be convicted. In the old days, the white community hated Italians. Why? Because they were swarthy looking. They were darker complexion. As confusing as all that is. So what does that have to do with anything? Nothing, absolutely nothing. But it's extra legal information. And if we look at the statistics, if we look at the criteria, then one of the things that we see is that this is really quite important. Okay, well, anyway, I'll stop talking about complexion. Why are juries' decisions influenced by irrelevant information? Calvin and Zeisels in 1966 in the liberation hypothesis. When the evidence is in a case clearly favors one side, juries will decide the case in favor of that side. And that's fairly obvious. But when the evidence is ambiguous, and usually that's the way it works. If you have a defense attorney, he's trying to throw up as many smoke screens as he possibly can. Because the prosecution has to prove that he's guilty. So they will throw up as many smoke screens as they can. They try to make it as ambiguous as possible. And if they can do that, then potentially it will be a toss-up. And that's one of the reasons why if you watch these shows about trials, they're never exactly sure what's going to happen. Because if the closer you have to a toss-up, the more likely that the defendant will get off. And of course, at this point, all this extra legal information is going to be something positive that's going to happen. Maybe O.J. was acquitted because he was considered, he was an actor. He'd been a football player at USC, and he was tried in California. So he was a local hero. So maybe that was part of one of the reasons why he was acquitted. That young lady down in Florida. I mean, the most heinous thing you can do is murder your child and bury her out in the swamp, which is what happened with that child. Somebody killed her and somebody buried her out in the swamp. And her mother was being tried for it. But she was cute. She was attractive. And she got off. Extra legal information. Not enough evidence against her. I don't know. If she had been a snaggle-toothed African-American woman, would she have been acquitted? Or would she have been convicted of murdering her child? Yeah, that's a good question. All of this stuff is really important as far as the decision is concerned, as far as jurors are concerned. I told you my brother was on a jury one time, and he tried the case. He tried the case in the jury room. One of the problems was that the individual that was being tried was African American, and he was very dark. And my brother understood all of this, and he knew that people were not seeing the evidence that was in front of them because of who this guy was. He was a mean-looking guy. He looked like he was a wife abuser. Why? Because he was very dark, and he always had a mean look on his face. So they assumed that he was a bad guy. And it's really easy to convict a bad guy. But of course, my brother looked past all of this because when he was in the military, he served with a lot of people that didn't smile. He served with African Americans that were very dark. So he didn't really see this as a negative thing. And he was able to, and they acquitted the guy for murder. Involuntary manslaughter is what they charged him with. One can understand jurors' attention to extra-legal information by applying cognitive experiential self-theory. When jurors deliberately focus on evidence provided during a trial, they are relying on a rationally based system of information processing. That is likely to occur when the evidence is unambiguous and comprehensible. As long as they understand what's going on, they're going to come up with a rational decision. These aren't people that are playing video games while people are giving them the evidence. These are people that are concentrating on what's going on. So they understand what's happening, as long as they can understand what's happening. Okay, so part of the problem, we're going to talk about expert witnesses in a second. Expert witnesses sometimes are thrown in there as a smokescreen by defendants. But when the evidence is contradictory or confusing, jurors may be more likely to rely on an experientially based system, extra legal information, of course, and that can be a problem. No idea what that has to do with. Okay. The influence of prior record evidence. Once jurors have heard evidence about a defendant's prior criminal record, they may be prejudiced by it, and the judge judge the current offense in light of these past misdeeds. In other words, they're not being tried on what has happened now, they're being tried on what has happened in the past. Why is it all blue all of a sudden? What's happening? Okay. So the prosecution is often not permitted to introduce the evidence. In other words, we can't talk about their past history. We can't talk about their criminal record. Of course, because that will prejudice the jury against the individual. But if the defendants opt to testify, then prosecutors may be able to question them about certain types of prior criminal involvement in order to impeach their credibility as a witness. And this is one of the reasons why, if you've ever If you've ever studied a trial or a trial procedure, a lot of times the defendant will not defend themselves. They will not take the stand. If they take the stand, all bets are off. They can talk about anything they want. The prosecution can ask them questions about their childhood. They can ask them questions about their military history. They can ask them questions about their past. And if they can do that, then potentially what they will do is they will throw up a new smoke screen. Why is that turning blue? It may be burning out. Okay. If the defendant takes the witness stand, the judge may issue a limiting instruction. Evidence of a defendant's prior record can be used to gauge the defendant's credibility, but not to prove the defendant's propensity to commit the charged offense. One of the things they're going to ask him is, did you commit this crime? And he's definitely going to say no. Otherwise, he would have pled guilty. But the question is, will they believe him? And the more crimes that he has committed in the past, the less likely that they are to believe anything that he says. And that's what they're talking about as far as credibility is concerned. Do we believe the defendant or do we not believe the defendant? That is the question. If a defendant has a military history, has a military record, and they were in combat and they killed somebody, what's the probability that they have killed somebody now? And they're saying, of course, they didn't murder this person, and the prosecution is saying they did murder somebody. So their military record can actually be used against them. This is an individual suffering from PTSD or whatever. So the question is, do we put the defendant on the stand? And most defense attorneys will, that's the last thing they want to do, is to put their client on the stand. Limiting instructions are rarely effective. Juries apparently rely on their knowledge of the prior record to convict defendants when their evidence in the case against them was weak. So if they have a criminal history, the 3 strikes you're out situation, if that is the situation, then potentially what will happen is that they will use their prior record to convict them this time. If they did it once, then they probably did it a second time, or a third time, or a fourth time, or whatever. So what's the probability? So we don't want to put that guy up on the stand. The impact of character and propensity evidence. Character evidence can be used to provide evidence on the guilt when it is relevant to the defendant, the alleged victim, or a witness. Although positive character evidence has little impact on the juror's judgment, evidence about negative character traits increases the likelihood of conviction. So one of your friends comes up and says he would never do this. This is the last thing he would ever do. And if you listen to the news, if you watch the news, usually that's what we see. Isn't that what we saw with the individual that shot up the concert in Las Vegas? His neighbors were saying, "Oh, he's the last person I would ever think would do something like that." Said the same thing about the guy that shot up the church. He's the last person in the world that you'd ever think would do something like that. We hear this all the time. So what does that mean? Does that mean you have any idea what your neighbors are doing? Right? Do you have any idea what your neighbors are up to? You do. Are they bad people? Or are they the last people you would ever think would go into a church and shoot the place up? Does anybody have any neighbors that you think are serial killers or mass murderers?
Maybe. Just kidding.
When you're around people a lot, you try to think positively about those select individuals. So sure, you're going to be completely confused when this person turns out and gets angry. You've never made them angry, so you have no idea what they're like when they're angry. So all of these people, of course, you don't have a clue that they're mass murderers or serial killers or would steal something. I had a student one time that he was a nice guy. He was really nice to me, and all of a sudden they arrested the guy. Turned out that he'd been He'd been stealing from people's houses. What happened was that he'd go to class with somebody, and he would learn what their schedule was. He was a real friendly guy, and he talked to people about their class schedule and how bad it was. And then when he found out that they weren't going to be home, he went over to their house and robbed them. And he was doing this, and he'd been doing this all semester. Nicest guy in the world. Kinda. So he could have used me as a character witness. Sure, I would have said, geez, seems like the nicest guy in the whole wide world. And all of the people that he talked to, that he robbed, they thought he was the nicest guy in the world as well. So this kind of evidence is not a positive. Doesn't have to be a positive. And for this reason, there are a lot of people that do not use character witnesses, because this means nothing. This means absolutely nothing. However, if they talk about somebody's character, and that character is relatively negative, then that will go a long way to convicting the individual. They'll use that against them. Yeah, I saw him beating his dog. Well, there you go. You saw him beating his dog, so obviously he would slit the throat of a 5-year-old girl. So yeah, we'll convict him for beating his dog, is what we're actually convicting him of. I saw him torturing little small animals. Obviously that makes him a mass murderer. So I don't know what I did. Okay, it's turned white again. Evidence of other crimes or wrongdoing, propensity evidence, is also typically inadmissible in court, and for that reason they will not present anybody's history. And of course they can't bring this up unless it's brought up by the defendant. If it is brought up by the defendant, then the prosecution can use it. If it's not, then they can't. In 1994, sex crimes are treated differently. An individual that has committed a sex crime in the past, then you can talk about the sex crimes. Then you can talk about those sex crimes. If he's a felon of one kind or another, if he's broken into somebody's house, you can't talk about that. But if he's committed a sex crime, this may mean that his testosterone level is too high, and he doesn't know how to control his sexual urges. In 1994, Congress passed a law making evidence of other sex offenses admissible to show a defendant's propensity to commit the charged sex crimes, sex offenses. So this is something that they decided in 1994. What was happening was, especially good-looking guys. I'm telling you, if you're attractive, you can get away with murder, literally. Donald Trump thinks that he could shoot somebody on Fifth Avenue and still get away with it. Why? Because he's so attractive? No, it's because he's got so much money. So there are a lot of things that carry a lot of weight in the United States. And one of them is money, and another one is appearance. So appearance has a lot to do with stuff. It can get you out of all kinds of interesting trouble. However, if you've committed a sex crime in the past, if you've been convicted of a sex crime, that will come out in your trial. Almost automatically. You've done it before, so did you do it this time, is the question. Now normally if you've done something like shot somebody, then nobody cares. Ted Bundy, my God, Ted Bundy was so pretty that, geez, they wanted to let him off every time they had him in court. And he was so smart. Everybody loves a smart guy. But of course he was a serial killer and a rapist and a murderer. He was kind of a mess. So since 1994, if a sex crime has been committed, it can come out in your trial. Although the vast majority of civil cases are resolved outside the courtroom, thousands of civil cases are tried before juries each year. These things come up all the time. Usually it's a high-end trial. AT&T, Time Magazine was just sold to somebody. It happened like yesterday. Time Magazine is gone. Or Time Incorporated, actually. Time owns a lot of stuff. I think CNN. They may own CNN, if I'm not mistaken. And they sold them to AT&T. Yeah, it went through. That ought to be interesting. Now, AT&T owns like all the media in the United States. So guess what we're going to see? We're going to get to see news as far as AT&T is concerned. Isn't that exciting? One of the things that happened, and of course you guys may not realize this, but a guy by the name of Rupert Murdoch, he's in Australia, decided he made his billions by printing tabloid newspapers. You know, those things that tell you that aliens have invaded Hoboken, New Jersey or whatever, that Ivanka Trump is actually an alien. Can't you tell by her nose or something? Okay, so you know, so it's that tabloid crap. Anyway, Rupert Murdoch, and then Rupert Murdoch started buying newspapers all around the world. The most important newspapers he could find. He owns Wall Street Journal. He owns he owns the other New York newspaper, not the New York Post, but or New York Times, but the New York Post. He owns the New York Post. He owns the Washington Times, not the Washington Post. Okay, but he owns the Wall Street Journal. This guy's a tabloid journalist. He also owns Fox News on television. So he's relatively conservative. This should get kind of exciting. So all of a sudden, all of the Wall Street Journal is the premier financial newspaper in the United States. So all of a sudden, our financial news is a lot more conservative than what it ever has been in the past. So this could get really, really interesting. Whoever owns something, they will impact that organization. So Time Magazine, which has been relatively liberal over the last 10 or 15 years, all of a sudden they're owned by a conservative company. So we'll see if they change. I get Time Magazine, so I'll tell you if it's changed, if it changes. Juries in these cases typically make two fundamental decisions, whether the defendant or we're talking about civil cases here, whether the defendant or in some instances the plaintiff is liable or responsible for the alleged harm, whether the injured party, typically the plaintiff, should receive any money to compensate for his or her losses, and if so, in what amount. These monies are called damages, so they have to decide what the damages are. So potentially we have a case, let's say somebody at McDonald's spills coffee on their lap and they get a third-degree burn. Okay.
Did that happen?
It did happen. Yeah, it happened. Yeah. So the idea was, well, so is McDonald's responsible for the harm that was done? He burned his lap. I'm not exactly sure what part of his anatomy he burned, but let's pretend it's his upper thigh, burned his upper thigh. I don't know. So the question is, are they liable for the damages? Do they have to pay for it? And how much do they have to pay for a hot cup of coffee? That was the question in that case. So how much would you give somebody for spilling coffee on their lap? Coffee. It's coffee. What do you think?
Are we including the transportation to and from the clinic?
Sure. Let's throw all that in. Both dollars. The ambulance ride. How much does an ambulance cost? $1,000. Okay. So you're going to give them $1,000. No, wait a minute. They have to go back and forth. They got that whole burn on their thighs.
They might want plastic surgery.
Plastic surgery. What's that? Another $10,000? That's $11,000.
Maybe they were traumatized.
Traumatized. Exactly. They were traumatized.
The smoke is
how
much
much?
they get out of the
$50,000.
Cash.
$50,000. What do you
down the
think?
trunk.
50,000?
Not to say million.
Is that too much? Too little?
Too little.
Too little? More money.
Attorney fees, court
Attorney fees,
Yeah.
court costs, exactly. You're taking on McDonald's.
You gotta buy your attorney breakfast.
Exactly. So we're talking, he needs plastic surgery to repair his leg loose.
She was saying like childcare too, like
Child care,
trying to have kids.
how much are your
It's
kids
serious.
worth, okay.
Yeah.
So what are you saying, how much? Let's come up with a figure. You're on the jury, this is a jury.
Million.
Millions.
10, 11 of us, okay. None? You're not, how much are you gonna give him? How much do you want to give
Oh,
this?
how much do I want to give?
This guy, yeah, he burned himself and McDonald's is liable because their coffee was too hot and now he's
Yeah, I'll
got
go with 50,000.
50,000?
Yeah, I would go
50,000? 50?
50,000.
50,000? 50,000? 50,000? 50,000?
Million.
A million. I got a million.
It's the hat.
You're on the jury, you gotta make a decision. 50?
Tim, I have a question.
Nothing? You're not gonna give him anything?
I mean, obviously, whoever it is money hungry. I mean, it's just a simple accident, and I mean, I had coffee spilled on me, and I didn't sue anybody for it.
Such a wimp. You should have taken it cleaner. Okay. Somebody want to look it up to see how much the guy got for the McDonald's thing? Does anybody have a computer up? No? Okay.
But didn't they already have like a warning label saying the cup is hot?
Now they do.
Probably
Oh, I thought they had it before.
afterwards.
Afterwards, exactly. And now they put a paper thing on the outside, paper sleeve on the outside.
So it doesn't burn.
Yeah, and that's what he complained about. That he grabbed the cup and the cup was so hot that he dropped it. Exactly. Because it was so hot. Must have been boiling.
That's what I was
Common
gonna
sense.
say.
3
common
million.
sense.
You got 3
Common
million.
sense. Well, here comes our 12th juror.
3 million?
You got 3
Final
million.
decision.
You got 3 million.
3 million.
Damages for the burns that
How much?
3 million.
3 million.
Oh, $3 million. You won 50,000. Oh my goodness. What could you do with $3 million?
But you're still through college?
Invest.
Go to the casino. Turn it into $30 million. Yeah. Or zero. Determining liability, jurors must determine the party's respective responsibility for the harm that was suffered. Jurors should decide liability on the basis of the defendant's conduct. This is kind of an interesting picture because I don't know, I'm sure I told you guys the story of my son was driving down the road and all of a sudden this guy came up behind him and he started ramming him. He didn't hit him once, he hit him 6 times. 85-year-old man in a much bigger car. My son drives a Mazda C3, I think. Yeah, I think it's a C3 or a 3. Mazda 3. There's a Mazda 3, which is a kind of a small car. Anyway, and this guy was in a Lexus. And he just kept hitting him. He hit him so hard that it curled his front bumper. This is the guy that hit him. Curled his front bumper underneath, and the only thing that slowed him down was the fact that his bumper was pressing up against his front wheels. He had curled his bumper up underneath his car. And it had split his radiator. So he tried to get away. He tried to drive down the road.
Hit and run.
Hit and run. And his car, all the water ran out of his radiator and he had to stop. But my son pulled off the road. He's trying to get out from behind or in front of him. Okay, so what about damages here? Liability. Anytime somebody hits somebody from behind, no matter whether they slammed on their brake, guess who's liable? The guy in back. Exactly. And in California, this is a thing that people will do. They'll suddenly slam on their brakes in the middle of heavy traffic. Yeah, and then you slam into the back of them and you're liable. This is a real popular thing that people from Mexico will do. They'll come up in their beater cars and get slammed in from behind by somebody. And then the insurance, of course, buys them a new car. which is not a bad deal. Anyway, okay, so one of the things you have to do is decide who's liable. And usually that's the guy who's behind. The severity of an injury or accident, sometimes referred to as outcome severity, though legally relevant to decisions about the damage award, should be irrelevant to the judgment concerning liability or legal responsibility. So the severity has nothing to do with it. Although the legal system expects jurors to evaluate liability objectively, jurors' emotional reactions also influence their assessment of the facts and evidence. Of course, we got Edison in the back who said, what a clumsy oaf you are for dropping your coffee cup. He's done it over and over and over again. It's never sued anybody. Your wife, for example, you have never sued your wife for the coffee being too. Okay, just a thought. Just a thought. Good. I'm glad she's pleased about that. Assessing damages, jurors put most weight on the evidence that they hear in court, but they sometimes consider attorney's fees and whether any loss is covered by insurance, issues that are theoretically irrelevant to decisions about damages. So the reality is that if you get a settlement, how much does the lawyer get? I think it's 30%, 33%. It's 1/3. Okay, so if you get a $3 million settlement, the lawyer gets $1 million. Yeah, that's the way it works. And that pays for lawyers' fees, I guess. So when the guy got the $3 million, he didn't get $3 million. He actually got probably closer to $1 million. $1 million went to his lawyer, and then $1 million went to everything else. So they may have taken that into account. So who paid them the $3 million? McDonald's, obviously. But did they really? Is that why your Big Mac is costing an extra 3 cents? 3 cents more than it used to? Is that why? Because of this $3 million settlement? Who had to pay? The insurance company pays. Of course the insurance company pays. I know, they have liability insurance. Of course they do. So do we mind charging insurance companies? We don't want to charge McDonald's. We don't want our Big Macs to go. Our quarter pounders with cheese to go up. Our French fries, which everybody loves McDonald's French fries. No, it's the insurance that pays for it. And everybody has to have liability insurance. Evidence indicates the judge's admonition to disregard inadmissible evidence is relatively ineffective. And if you watch these things on television, they're always trying to bring up evidence that they're not supposed to bring up. And then the judge will say, please disregard all that, everything that has just been said. Can you do that? Well, the answer is no. Hell no. You sure can't forget that this guy said that. You can't, that is evidentiary. And this is known as Reactance Theory. It explains that instructions to disregard evidence may threaten jurors' freedom to consider all available evidence, of course, and this is a really serious problem in trials. So despite the fact that they're not supposed to bring anything up, sometimes they do. Or sometimes it comes out during the case, in which case the judge will say, please disregard that last statement. Can you disregard any statement? And the answer is no. It's still in your mind, and it's still going to be part of what you're thinking about. Now, when he gives you final instructions, he will tell you, please disregard all of this information. This is irrelevant to the case. But the reality is, of course, you can't do that. That must be it right there. Okay. Simply providing jurors with a reason for the inadmissibility ruling makes them more likely to comply with it. Jurors may think more about inadmissible evidence as a direct consequence of their attempts to follow the judge's request to suppress thoughts of it. And this is known as thought suppression phenomenon. But of course, the more you try to not think about it, the more you think about it. Because you're trying to think, you're not trying to think about it. I can't remember the blue rhinoceros. I can't remember the blue rhinoceros. Okay. So you're not thinking about the blue rhinoceros. Yes, you are. That's exactly what you're thinking of. You're thinking, I can't think about the blue rhinoceros. Jury deliberations can lessen the impact of inadmissible evidence. So the more you talk about it, of course, the more that you can discount it. So jury deliberations, somebody says, yeah, but don't you remember he said that he was on 3rd Street. And then the guy will say, well, we can't even think about that piece of evidence. And so they will actually take this into account. And this will make it less likely that that will impact the decision. Experts typically testify about specialized knowledge with which most jurors are not familiar. Because jurors lack rigorous analytical skills, they may use unsystematic or effortless experiential processing, leading them to attend to peripheral aspects of the expert's testimony rather than the content of the testimony. Anyway, and so what is happening here, we've got a juror that is getting all this information, and I don't know if you understand mathematics or not, but you do? You understand all this?
Yeah.
Okay.
Not all of it, most of it.
Okay. But most people don't understand that. I don't even understand the titles of the classes my son is taking. He's a math major. It's driving me crazy. I can't understand. I have no idea what he's taking. You know, I understand geometry. I understand that. But some of the crap that he's taking makes no sense whatsoever. So these expert witnesses will come in and they'll give you all of this pile of information, and you don't have the expertise to understand what he's talking about. Okay. So they have to put it in common language, and sometimes that's almost impossible. You guys have information that if you talk to your friends about it, they won't have a clue what you're talking about. Probably, because you understand psychology, and they may not understand psychology. You'll be able to read people now because you are taking all these psychology classes, so you'll be able to look at somebody and understand what they're thinking, and your friends will go, oh, that's not true, that can't possibly be true. I lost a wife over that. I started studying psychology and she thought I was analyzing her all the time. She thought that I was going to tell her how crazy she was. I didn't tell her how crazy she was until after she left. But she assumed that I was going to be psychoanalyzing her, which is partially true. When she did start acting erratically, I did start thinking, oh, well maybe this is the reason why. And that's why I kept studying psychology. I kept studying psychology trying to figure out what the hell was wrong with this lady. And I figured it out. Eventually I figured it out. It had to do with the way that she was raised. I know, it's crazy. Let's hypnotize people. Oh, concern. Expert testimony will mesmerize jurors, causing them to discount their own common sense and rely too heavily on the opinions of experts. Do jurors place undue weight on testimony from experts? A number of studies show that jurors do not defer to experts, but expert testimony exerts a small, reliable effect on their decisions. In other words, it either supports their decision or they discount it. So if the expert is saying things that they think is true, then it has an impact. If it doesn't, if they don't understand what the guy's talking about, it doesn't mean anything at all. So you can have all the expert witnesses that you want, and unless the jury can understand what he's talking about, then it's not going to impact the result of the trial at all. Now, a lot of times you can go back and if the individual is convicted, you can use this to get a mistrial. If the expert witness didn't make his testimony understandable, they can use that as a way of getting a mistrial. So when we talk about expert witnesses, when we talk about psychologists being expert witnesses, the psychologist has to talk in terms that the jury can understand. And if they don't, it's not going to work. It isn't going to work. That's just the way the world works. Judges who ultimately decide what expert evidence is admitted in court may allow unreliable expert testimony to be admitted into evidence. And of course, this is a case for mistrial as well. If they allow expert witnesses that don't have anything to do, or if it's isn't really evidentiary, but they are allowing them to testify anyway, then one of the things that will happen is that they potentially will call a mistrial. And this is Daubert versus Merrill Dow Pharmaceuticals Incorporated, 1993. The pharmaceutical company was bringing in expert witness after expert witness, and a lot of the expert witnesses were just smoke screens. It was trying to show the jury that they didn't understand chemistry well enough to be able to make a decision. And of course, they found for the pharmaceutical company. But when they took this to appeals, when Daubert took this to appeals, one of the things that they discovered was a lot of the testimony didn't have anything to do, wasn't evidentiary. It didn't have anything to do with the case. And for that reason, they called a mistrial. And when they retried the case, Daubert won this time. And it was because the only testimony they allowed was testimony that had to do with the case. Now this is really kind of interesting because it all has to do with the judge. The judge decides which expert witnesses they're going to allow. And if the judge is in favor, in this case the judge was in favor of the pharmaceutical company, big business. With the administration that we have now, we're going to see this more and more, that business will trump everything else. And I use trump as if we're playing cards, not capital T. Okay. I know. Sorry about that. Anyway, we're going to see this more and more because he's very positive toward big business. We saw this with the second Bush administration. I don't know if you remember when he was first elected in 2000, George W. But there was a scandal going on with Enron. You remember Enron, or maybe you don't remember Enron. Enron was an energy company, and Enron gave a lot of money to to his presidency. They supported his candidacy for president. As it turned out, Enron was ripping people off, and so when it went to court, initially when it went to court, the Justice Department was in favor of letting Enron pass, giving them a pass. But as it turned out, of course, there was so much evidence against them that the Justice Department had to come back and of course Enron doesn't exist anymore. They were the largest energy company in the United States, and they don't exist anymore. And the reason is because they were ripping people off. And of course that was a huge scandal as far as George W. Bush was concerned. Anyway, that's all taken care of. Same thing happens. I mean, judges, they have prejudices as well. They can be prejudiced toward the defendant. They can be prejudiced toward the other side. And this is one of the arguments that people are having right now with the Trump administration. This is one of the arguments that a lot of people had against the Obama administration. The Obama administration seemed to be more liberal, and they were putting judges on the bench who were more liberal, who were looking at different things. They were looking at the defendant as more positively. They weren't arresting as many people. They weren't throwing as many people in jail. And now with the Trump administration, he's switched that. So he's taking all those liberal judges off the bench and he's putting in more conservative judges. I was reading an article about that last night. and they were talking about how things are going to change because the focus is different. It's totally different now than it was before. So we may see more people that are thrown in jail. We may need bigger jails. So if you're a jail builder,
Jail owner.
I know. One of the things that happened with the Bush administration, I was up on the Fort Belknap reservation at the time. They built a new jail on the reservation. They decided that the way they were going to control the problem on the reservation was to build a bigger jail. So that's what they did. They built a bigger jail, and they increased the number of policemen on the tribal policemen. Really kind of curious. That's how they're going to take care of the crime problem on the reservation, is build a bigger jail. Did it work? No, it didn't have, no. The cells are still just as empty now as they were with the old jail. Building a new jail isn't going to make people want to go to jail and fill up all the, I don't know, it was really kind of stupid. Anyway, but it made people feel better. Are jurors able to distinguish between reliable scientific evidence and junk science? In general, jurors have been found to be unable to distinguish valid from flawed research. Okay, so what about global warming? Is global warming, is that good science or bad science? This has become a political issue. The Obama administration was very much in favor of controlling human waste and whatnot, carbon dioxide being put off into the atmosphere. They were very much in favor of that. This administration, not so much. So is it junk science or not? Is there really global warming? Does it really exist?
Yes.
I got one yes. What do you think? Yes, it does exist. It does exist. Global warming, is it real? Global warming. What do you think? Yep. Yep. I got a yep. I got a what do you think? It's not real? It's not real at all? Okay, it's junk science. It's not real. Okay. Interesting. Okay. So sometimes if we look at one scientist, he's going to say, obviously, global warming is real. And if we look at another scientist, they're going to say no. When I was working at Ashford, the head of our department, who was a biochemist, said that global warming is a fraud. It's a sham. That's what he said. And he was my boss. And he used to yell at me all the time because I think global warming is real. I think humans we put off too much carbon dioxide. Our carbon footprint is too vast. Yeah, I think we're destroying the earth. But my boss didn't believe it. So he came down on me and said, you can't talk about that anymore. And of course, he was a scientist. And he's telling me I can't talk about global warming anymore. And he was telling the other scientists who believed in global warming, he was telling the other scientists to stay away from this issue, which was kind of curious. Guess what happened next?
Jurors talk about it?
They talked about it anyway. We have freedom we have freedom to say whatever we want in class, don't we? So I can say whatever I want. I don't have to listen to my boss. Did he fire me? He yelled at me, but he never fired me. One problem was he had 13 students, and I had 125 students. So which one of us was the more important instructor? Exactly. He had 13 students in 3 classes. He had 13 students in 3 classes. Oh, no. I had 56 students in 1 class. My God. So, okay, anyway. Nah, I didn't listen to a word. Jackass. Dumb as dirt. It's very conservative individual. Anyway, as it turns out, So the question is, do you believe it or not believe it? Now the reality is that you have the right to believe anything that you want. Whether you don't, you can see it as junk science or not. I had an argument when I first got here with Dr. Kine, who was Dr. Unsworth at the time, but I had an argument with her about whether subliminal messages were real or not. And this is one of those toss-ups. Is it real or is it not real? Well, she was taught at Northwestern that it's not real. And of course, I've been studying subliminals for 40 years. And I've watched subliminals come out of or become very popular and then lose their popularity. So she just kind of hit it at one of those low points. That's the way I saw it, because I've been around forever. I know, I'm old. I've been teaching psychology longer than she's been alive. And because of that, I've seen a lot of stuff. And of course, she has the education that she has, and she believes what she believes, and that's fine. But the question is, are subliminals real or are they not real, is the question. And she says no, and I say, yeah, I've seen them work. Okay. Anyway, but that's not important. My point is that as scientists, we have the right to believe anything that we want, to support any idea that we want. And so what is junk science? Are there junk sciences out there? And the answer is yeah. There are a lot of people that are studying in a strange direction. The serious weakness for many jurors is their inability to understand their instructions. The instructions are often full of legal terms that are unfamiliar to lay people. The only people that can understand what the hell these lawyers are talking about are other lawyers. And a lot of times the words that they put in there are put in there so that the common man doesn't understand what the hell. They have to hire a lawyer in order to understand it. Okay. This is important because they need money too. They need a job. They work really hard. So they have to create these illusions that only they can understand this stuff. And the reality is, of course, sometimes understanding laws is not the easiest thing in the world. This is what happened to us over the summer. We were reading online about the laws of Florida. And I was reading it one way, and of course when my daughter went to see the lawyer was telling her, well, sometimes that's true and sometimes that's not true. All depends on the judge, all depends on the jury. It was all a toss-up as far as they were concerned, and I was seeing it positively as far as my daughter was concerned. So it was kind of a mess. But she needed a lawyer in Florida in order to just get her off. She was hoping, the father of the child of my grandson was hoping that we wouldn't go to a lawyer because he didn't have much of a case as far as keeping the kid in Florida, since he had never actually taken care of the kid. He had never been the custodial parent. What's the probability that he can take the child away from a custodial parent that has no negatives? The only negative is that she wanted to move out of state. It was really kind of an interesting situation. And we needed to go see a lawyer so that we could file a brief to allow her to leave the state. And that's exactly what happened. The jury listens passively as the judge reads the instructions aloud, and they are almost never allowed to ask questions in the courtroom to clarify misunderstandings they may have about the law. In most courts, they are not allowed to question anybody. They're not allowed to say anything. They can't even talk to each other until they start deliberating. That means after the case has started. So they can't even discuss the case with the other people on the jury. Psychologists have been able to simplify jury instructions that have shown to be easier to understand by jurors. Several states have recently revised portions of their jury instructions. I know. Exactly. Okay. So they have actually made it easier for them to understand the instructions. Although instructions are typically read just before the jury deliberates, some of the states now require judges to provide a preliminary instruction before the evidence is presented. Instructing the jury at the conclusion of the trial reflects a belief In the recency effect, the recent events are generally remembered better than the more remote ones. So they don't give you instructions at the beginning of the trial. They give you instructions at the end of the trial. And then they tell you what they want you to think about. Now the problem is that they needed to tell you what you needed to be looking for during the trial. Otherwise, you may be focusing on the wrong thing. Okay. But, of course, this is the way it is traditionally done, that you do not get instructions until the very end of the trial. And this has to do with the recency effect. The delivery of jury instructions at the beginning of the trial rests on the notion of the primacy effect, that instructions will have their most beneficial effect if they are presented first. In this way, jurors know that the rules of the trial and the requirements of the law before the trial commences. So they're thinking in terms of what we need to be thinking about. This is how we will need to deliberate. So the primacy effect has to do with giving them instructions at the beginning rather than at the end. Forster, Lee, and Horowitz in 2003 reported that mock jurors who received instructions at the beginning of the trial recalled and used more of the evidence than did jurors who were instructed after the evidence. So research seems to say that the best time to give people instructions is at the beginning, not at the end. That's according to Forster, Lee, and Horowitz. All right. But it all depends on the judge, it all depends on the state as to when you give instructions. Jury notification, this is the implicit power to acquit defendants despite evidence and judicial instructions to the contrary. Research suggests that jurors tend to rely on their feelings and sentiments and to nullify the law only when the law seems unjust. Are there unjust laws out there? I don't know. Speed limit laws? I'll tell you what, I drove from here to, where did I stop? Clinton, Oklahoma. And I'll tell you what, the cops are out in force yesterday. I didn't see a single cop just sitting on the side of the road. They all had their lights flashing and they all had somebody stopped. I know. And everybody was out. The town polices were out, the sheriff's department was out, the state patrol was out. They were everywhere. I saw them in New Mexico, I saw them in Texas, I saw them in, and I passed a Texas state trooper, Texas state something, I don't remember what they're called. Anyway, he was going, the speed limit in Texas is 75. It's 75, and he was going 65. And he had a line of traffic behind him. People were afraid to pass him. Even though he was going 10 miles under the speed limit, he was trying to slow people down. And I passed him. I was going the speed limit. Well, I was going the speed limit. Normally I was going 80, but when I passed him, I was going 75. I was a good boy. I was going the right speed. So the question is, are there unjust laws out there? Can the jury discount a law? Can they overlook something? This has been the case with marijuana. There are a lot of people out there that think that marijuana should be legalized. And it is legal in what, 7 states? I think. Right. California, Idaho, Washington, Colorado, Maine, Washington, D.C. I don't know. I can't remember. Anyway, not important. They tried to legalize it in Arizona. It was not legalized. Okay. So is this one of those laws that we should overlook? If it's legal in Colorado, should we convict anybody in Arizona for breaking the law? They were talking about a guy yesterday in, you live in Pianta. How close is that to Colorado? 2 hours? That's pretty far. I mean, you could live right on the border. Couldn't you?
Aztec.
Yeah. Aztec, there you go. Okay. You could live right on the border. So what if you had a little bit of pot? Should you be convicted? I mean, the guys right across the street they're smoking pot legally. Right? Is that okay? Should pot be illegal? I was listening to a case yesterday, and they were talking about this guy that had a trash bag full of marijuana.
Yeah, it's kind of extreme.
Well, when they arrested him, or when they stopped him, and they found the trash bag full of marijuana, he claimed that it was all for him. He wasn't going to sell it. I don't know, it was like 15 pounds or something. How much marijuana can you put in a trash bag?
That's probably that force flex.
Dude, I'll smoke this up in a week. That's what he told him. But he was put in jail for a year and a half. This was before there were so many states that had legalized marijuana. Colorado. Yeah, but Colorado had legalized marijuana, so did Washington State. And this guy was from Colorado. And the thing was that when they legalized marijuana in Colorado, there were no marijuana farms in Colorado. Well, there were, but hardly any. Not very many. There are a lot more now. So he was transporting marijuana back to Colorado commercially. That's what he thought anyway. Didn't have a permit. I don't know what people are thinking. Anyway, he got caught. And they put him in jail for a year and a half, despite the fact that he was from Colorado. And if he had made it across the border, it would have been legal. So should they have convicted him? He's from a state where it's legal. He could have all the marijuana that he couldn't. That's not. Even a trash bag full of marijuana is still illegal. You have to get a license to be able to sell it. So should they have convicted him? Should they have thrown him in jail for a year and a half? I think going, dude, they shouldn't have been arrested, man. Come on. And I heard him on the radio. He still talks like that. He still talks like he's high.
They should have just feed him transportation.
Transport him across the line, take his baggie away from him, and transport him across.
Yeah, you were talking a little too fast too.
Dude, yeah, you're right. Actually, you're right. Yeah, because making those connections in your brain, everything's just a little slower than it was for normal people. Yeah. Okay. Anyway. I don't know. Are there laws that we shouldn't follow? Should we throw people in jail for speeding? Should we throw people in jail for drunk driving? I know. Well, this is kind of interesting because in Montana, people live really far away, okay? Everybody lives far away. So everybody has to drive a long distance. So if you want to go to the bar, how the hell do you get home? There are no taxis that run from the bar just 2 towns over. How are you going to get home? Jeff?
Pass out in the bar. You can see it.
Sleep on the pool table. Of course you sleep on the pool table. So the question, and they tried to pass a law that if you're driving home from the bar, that you can't be charged with drunk driving. They tried to pass it. I know. That's stupid. It's dangerous. It's ridiculous. Anyway, are there unjust laws out there? Potentially. I had a student, and her son died in he was drunk, and he had an accident, and he killed himself. And she swore that it was the state's fault. She tried to sue the state because they had a law that you couldn't drive drunk. But the rationale, it was rational as far as she was concerned. And of course, I just brought it up in class one day. I didn't mean to bring it up in class one day, and my God, I got she talked for 15 minutes about how this is the most unjust law there possibly could be. How in the world do you expect people to get home from the bar? How do you expect people to get home from the bar, Jeff?
You can camp out. Camp out in the car spot.
So whose fault is it? Obviously it's the state's for not writing the right laws. Okay. Just an interesting thought. Jurors' online activities, web browsing and posting prior to, during, and after a trial raise concerns about whether a criminal defendant's Sixth Amendment right to a fair trial can be protected. Jurors can get access to information from unknown and unreliable sources. So you can Google things potentially while you're a juror if you are allowed to use your cell phones. Potentially you can Twitter about the case that you're
You're not supposed to do that.
I know it's against the law. In most cases, it's against the law. But this is something relatively new. I mean, how long have we had cell phones? How long have we had the internet? I keep talking about the internet. 93, exactly. 1993. So we haven't had. I mean, and these are old farts. I mean, I just got a cell phone my wife just bought me a cell phone. And you saw my flip phone, the one I had before. So these are old people. The people that are the judges, the people that are the lawyers, these are old farts. And they don't really understand what you guys are doing with telephones. They don't understand that you can get on the internet with your telephone. They don't understand that you can Google stuff. $3 million. You can Google stuff on your damn telephone. They don't understand it's a computer. That you can gain access to the internet with cell phones. They don't understand this stuff. So they see somebody messing with their telephone in the jury box, and for a long time they didn't recognize what was going on. But now, of course, most people are fairly well aware of what's going on. But once upon a time, of course, judges are old people. They're not young people. They don't understand how you guys work.
I have a question. Do they ever tell them to put their phones and stuff in an area where they cannot see it while the jury,
I don't know.
I'm just curious. That sounds...
Yeah, I don't know. And if you've got an iPad, you're taking notes on an iPad. Actually, in some states you can't take notes.
Oh.
I know, which doesn't make any sense at all to me. Sometimes you need to write things down. But in other states, you can take notes. And in those states, you could just say, I'm using my iPad to take notes, and the judge is not real bright. How long have we had access to the internet from our cell phones? I mean, how old is this technology? Smartphones. It started with smartphones. How long have we had smartphones?
10 years.
10 years?
End of the 90s,
Well, not only that, but it was expensive. I mean, it was really expensive. Yeah. Yeah, it was extremely expensive. So not everybody had it. And the other problem was that in the beginning, the iPhone was the only smartphone, right? And then the Android, wasn't the iPhone was the first one.
Yeah.
And it was AT&T. And AT&T, right. It was AT&T, and this was what, 2003, 2004, 2005. So that's the first smartphone. Now we have Androids. Now we have all these other smartphones. Everybody has a smartphone, right? Get a smartphone? It's smart. It's a smartphone. And obviously you have a smartphone because you gave me that information. I'm talking about computers, and you're popping this thing in. You're Googling on
Didn't they have that one pocket pad too?
They had Blackberries.
The Blackberries before that.
They had Blackberries,
Yeah.
right. But Blackberries were extremely expensive, and they're very specific as to what information you could get off of them.
Never got that.
Right.
Wasn't there a sidekick or something?
Yeah.
Okay. But this was very expensive, and it wasn't very common for people to have this. Your kids didn't have access to the internet because it was too expensive. That was in the old days. Now, when all this first came out, I was in Montana. AT&T doesn't service Montana. So nobody in Montana had an iPhone. Of they couldn't have iPhones because they couldn't get served unless, I don't know, you were on the border or something, I don't know. Anyway, so they didn't have iPhones. So this is in like 2003, 2004. So all of this technology has erupted just in the last 10 years or so. So yeah, judges are kind of far behind, and so are the lawyers. So the other question is, do they allow electronic devices in the court? And it is almost time to stop. Okay, why don't we stop right here? We'll pick this up next time, and we'll talk about cell phones more next time. Since I'm so knowledgeable about all this stuff, I just learned how to Google last week. So. All my pictures are from Google Images. You know I know how to Google. I've been Googling for decades. I'll see you guys next time.
Oh, your light's on.
Good point. Thank you, Jeff. What am I going to do without you, Jeff?